Okay, good morning. We're here in Public Service Commission Docket 16-03501 in the matter of Rocky Mountain Power's application to decrease the deferred EBA rate through the energy balancing account mechanism. We'll start with appearances for the utility.
Good morning, Yvonne Hogel with Rocky Mountain Power. With me supporting the stipulation is Mike Wilding, who is the manager of Net Power Costs. And also with me today, who are here to answer any questions that you may have, are Jeff Larson, VP of Regulation, Joelle Stewart, who is the Director of Rates and Regulatory Affairs, and on the phone, Dana Ralston, who is the VP of Coal Generation and Mining. Thank you.
Okay, thank you, Ms. Hogel. Ms. Schmidt?
Good morning. Patricia E. Schmidt with the Attorney General's Office for the Division of Public Utilities. The division's witness supporting the stipulation today is David Thompson. Also in the audience is Dr. Artie Powell, who's available to answer questions as he was a witness and provided testimony. On the phone, we have Dan Kaler from Daymark, the division's consultant. He's also available to answer any questions.
Okay, thank you. Mr. Olson?
Rex Olson, representing the Office of Consumer Services, and with me in support of the stipulation is Danny Martinez.
Okay. Thank you, Mr. Dodge.
Thank you, Mr. Chairman. Gary Dodge on behalf of UAE. UAE filed testimony of two witnesses, Bradley Mullins and Kevin Higgins. Mr. Higgins is in the room to answer testimony, or to answer questions. Mr. Mullins can be available by phone if necessary, but we don't intend to call them as witnesses except to the extent you have questions.
Okay, thank you.
Thank you.
I'll ask the court reporter at this point if there's any concern with having the witnesses stay at their seats on the table when they testify today instead of coming up here. Does that work for you? Okay. Any other preliminary matters before we start then? Ms. Oh. Did you have something?
Oh, I thought you were going to. Sorry about that.
Oh, Ms. Ogle?
Yes, please, thank you. I'm wondering if your preference would be for us to move for the admission of all of our witnesses' testimony about testimony in case first, and then call our witness supporting the stipulation, or
You mean for all, admitting this testimony of all parties, or just for all of yours?
For Rocky Mountain Power.
Just for all of yours. That's, unless there's any objection from any other party, that seems efficient.
Okay.
So if there's any objection, let me know. But
Okay, Rocky Mountain Power then moves for the admission into evidence of the following testimony: direct testimony in exhibits and work papers of Michael Wilding, direct testimony in exhibits of Joelle Stewart, revised responsive testimony in exhibits of Michael Wilding, both clean and red line versions, responsive testimony of Dana Ralston, and supplemental testimony of Jeff Larson.
is there any objection to entering that all of that testimony is described by Ms. Hogel into evidence? Please just indicate to me if there is. And I'm not seeing any, so that will be entered. Thank you. Okay, if you'd like to go ahead.
The company calls Mr. Michael Wilding, and he would need to be sworn.
Mr. Wilding, do you swear to tell the truth?
Yes.
Thank you.
Good morning, Mr. Wilding. Can you please state your name and your position with Rocky Mountain Power?
Yes, my name is Michael Wilding. My position is the manager of Net Power Cost.
And what is the purpose of your testimony today?
I will briefly review the history of the events and the key elements of the stipulation entered into by the four signing parties, including Rocky Mountain Power, the Utah Division of Public Utilities, the Utah Office of Consumer Services, and the Utah Association of Energy Users. I will also reconfirm Rocky Mountain Power's support of the stipulation and the company's belief that the stipulation is in the public's interest.
Can you please recount the relevant key events that led to the settlement stipulation that you are presenting here today?
Yes, the company filed its annual Energy Balancing Account, or EBA, application on March 15, 2016, for the deferral period of January through December 2015. The company requested recovery of $18.9 million, which included $11.3 million for deferral of excess EBA-related costs, which are calculated as 70% of the difference between actual MPC and wheeling revenues and base MPC and wheeling revenues. Pursuant to the stipulation in docket 14-035-147, the EBA application also included $9 million for the Utah allocated amortization expense associated with the closure of the Deer Creek mine, and a credit of $2.8 million for the Utah allocated coal fuel expense savings also at the Hunter and Huntington plants, also related to the closure of the Deer Creek mine. Lastly, the EBA application included $1.3 million of interest. The division issued its report on the EBA and proposed a reduction to the company's EBA application of approximately $1.2 million. One of the adjustments proposed by the division was a disallowance of the carrying charge on the Deer Creek amortization expense. In my direct testimony responding to the division's EBA report, the company revised its EBA filing to $16.2 million. First, the company included non-fuel savings related to a reduction in the retiree medical benefit obligation after the closure of the Deer Creek mine, which decreased the EBA by $2.9 million. Second, the company made a correction to its coal costs, which increased the EBA by approximately $350,000. The office proposed to reduce the EBA by approximately $1.3 million, and UAE proposed to reduce the EBA by approximately $3.3 million. Included in the UAE's proposal was the non-fuel savings related to the retiree medical benefit obligation. Some of the proposed adjustments overlap between parties. For example, all parties supported the disallowance of the carrying charge of the Deer Creek amortization expense. Over the last few weeks, the parties have engaged in settlement discussions, and based upon those discussions, the parties have agreed to the terms and conditions set forth in the stipulation. After a collaborative effort, the parties have reached an agreement resolving all issues raised in the EBA. The proposed settlement results in recovery of approximately $15 million, which is $3.9 million less than the company's initial EBA filing and $1.1 million less than the revised EBA amount.
Can you please describe the adjustments in more detail?
Yes, as part of the settlement stipulation, the company has agreed to 3 monetary reductions to the EBA. First, we've agreed to a $500,000 reduction to resolve the proposed adjustment to the carrying charge on the Deer Creek amortization expense. Second, $350,000 from reversing the correction to coal costs that was included in the company's revised filing. And third, $250,000 to resolve all other proposed adjustments. The company also agreed to provide additional information and support for parties to gain a better understanding of the benefits of the Energy Imbalance Market, or EIM. And on September 29th, the company held a workshop with parties to discuss the calculation of the EIM benefits and EIM settlement accounting. Additionally, the company affirmed that in any future filing in which the company seeks approval for expansion of participation in a regional independent system operator, the company will demonstrate a net incremental benefit beyond that which has been achieved through participation in the EIM. Paragraph 8 of the stipulation indicates that the rate spread and rate design for the stipulated amounts are consistent with the company's initial filing as set forth in Attachment A to the stipulation. The remaining paragraphs of the stipulation contain the general terms and conditions, which are associated with most stipulations presented before this commission. They represent the obligations of the parties to the stipulation and to each other. As with most stipulations, this agreement was reached through negotiation and compromise. Each party became comfortable with the agreement in a different way, and nothing in this stipulation shall be considered precedential in any future case except with regard to issues expressly called out and resolved by this stipulation. This stipulation does not resolve and does not provide any inferences regarding any issues not specifically called out and settled herein.
Mr. Wilding, do you have any final comments that you would like to give?
Yes. In closing, the company respectfully requests the commission approve the settled stipulation and all of its terms and conditions and the new rates effective November 1, 2016. The new rates will result in a rate decrease for customers of 0.8%. We appreciate all parties, the division, the office, and UAE, and their efforts in reaching this agreement. Thank you.
Thank you. The witness is available for questions.
Okay. Ms. Schmidt, do you have any questions?
No questions?
Mr. Olson?
No questions.
Mr. Dodge?
No questions.
And I think, unless there's any objection from any party, I think we'll save any questions from the commission until all parties have presented, and if anyone objects to that, let me know. Okay, Ms. Hogle?
Oh, no.
You're finished?
Yes.
Okay.
The company rests, thank you.
Okay, thank you. Ms. Schmidt?
Good morning. Before our witness speaks, I'd like to move for the admission of the DPU exhibits. They would be DPU exhibit number 1.0, 1.1, 1.2 confidential, 1.3 confidential, 1.4 confidential, and 1.5. Those are the direct testimony and exhibits of David Thompson filed on July 15th of 2016. We'd also like to move for the admission of the testimony of DPU witnesses Phil DiDomenico and Dan Kaler. They would be DPU exhibit number 2.0 direct, DPU exhibit number 2.1, 2.2, 2.3. 2.3 is confidential. Finally, we'd like to move for the admission of the testimony of DPU witness Artie Powell. Dr. Powell's exhibits are DPU exhibit number 3.0 direct in both clean and red line form. Those were filed on September 28th of this year.
Okay, thank you. If there's any objection to the admission of that testimony and exhibits as described by Ms. Schmidt, please indicate to me. And I'm not seeing any, so those will be admitted. Thank you.
Thank you. The DPU would like to call Mr. David Thompson as its witness in support of the stipulation. Could he please be sworn?
Mr. Thompson, do you swear to tell the truth?
Yes.
Thank you.
Mr. Thompson, just a couple preliminary matters. Could you please state your name and employer for the record?
Yes, my name is David Thompson. I'm a utility technical consultant for the Division of Public Utilities and have participated in this docket on behalf of the division. My business address is 160 East, 300 South, Salt Lake City, Utah, 84111.
Do you have a statement evidencing the division's support for the stipulation?
I do.
Please proceed.
Thank you. Good morning, Commissioners, and thank you for the opportunity to express the division's support of the stipulation signed by the parties in this docket. The division believes the stipulation, including the agreed-upon recovery of $15 million, is just and reasonable and in the public interest. The company has already discussed the history and the details of the stipulation. On behalf of the division, I will discuss a few specific sections of the stipulation. The division would like to state that it supports Section 8 having to do with the rate spread and rate design for the recovery amount. It also supports Section 10 and Section 11, which have been commented on by the company and are non-numerical provisions of the settlement. The information requested in these sections should provide a better understanding of the EIM and any future benefits of participation with an independent system operator. After its direct testimony, the company recovery amount was $6.2 million. In the division's EBA report and my testimony filed on July 15, 2016, the division proposed a net reduction adjustment totaling approximately $1.2 million to the initial filed recovery amount of the company. Section 5 and Section 6 of the stipulation outline 3 settlement adjustments that reduced the $16.2 million by approximately $1.2 million, making the settlement amount $15 million. The settlement adjustment amount is equal to that sought in the division's EBA report and testimony. The division believes that the company is maintaining its commitments made in prior EBA dockets to improve the audit process and appreciated the company's willingness through phone conferences and other means to discuss the many aspects of its filing. In conclusion, the division is in support of the company recovering the stipulated $15 million EBA deferral for calendar year 2015. And that concludes my summary.
Mr. Thompson, you highlighted a few of the stipulation's provisions. Is it true that the division is supporting approval of the stipulation as a whole?
Yes.
Thank you very much. Those are all my questions for Mr. Thompson. He's available as you wish for questions.
Thank you. Ms. Hogle, do you have any questions for him? Mr. Olson?
No questions.
Mr. Dodge?
No questions.
Okay, thank you. Ms. Schmidt, anything further?
Nothing further from the division.
Thank you. Mr. Olson?
Thank you. I'd like to call Danny Martinez and have him sworn, please.
Mr. Martinez, do you swear to tell the truth?
Yes.
Thank you.
Mr. Martinez, for the record, could you state your position with the Office of Consumer Services and your address?
Yes. My name is Danny Martinez. I am a utility analyst with the Office of Consumer Services. My business address is 160 East, 300 South, Salt Lake City, Utah, 84111.
And at this time also, if the commission pleases, I would like to move for the admission of certain testimony, the direct testimony of Mr. Phil Hyatt and the confidential version and the redacted version with associated exhibits, which was submitted on August 18th, 2016, and the revised direct testimony of Danny Martinez, both confidential and redacted, which were submitted on September 28th, 2016.
Okay, thank you. If anyone objects to that motion, please indicate to me. I'm not seeing any, so that will be admitted. Thank you.
Thank you. Mr. Martinez, do you have a statement for the commission on regarding this stipulation?
Yes.
State it, please.
Sure. Good morning, Commissioners. The Office of Consumer Services reviewed Rocky Mountain Power's EBA application and the Division of Public Utilities audit report in Docket 16-035-01. The office enlisted the services of Mr. Philip Hayette to assist us in the assessment of the company's application and the division's audit report. The office filed direct testimony in which it recommended to the commission adjustments to the company's EBA application. The office believes that the terms of the settlement agreement adequately addresses all of the concerns identified in the office in that testimony. Further, the office notes that it filed revised direct testimony consistent with the terms of the stipulation. The office would also like to take a position regarding the technical workshop addressed in the letter from the company to the commission dated September 28, 2016. That letter described a workshop attended by the parties to this settlement stipulation on September 29, 2016. The letter further states that, quote, the company is willing to conduct additional workshops on EIM to accommodate interested parties that were not aware of the workshop being held tomorrow or to give time to the commission to issue appropriate notice, close quote. The office asserts that the topics addressed in that workshop are appropriate for a technical conference to be attended both by the commission and its staff, as well as other interested parties who have signed the appropriate confidentiality agreements. Accordingly, the office recommends that the commission consider how to best notice and schedule this follow-up technical conference at its earliest convenience. In summary, the office believes that this settlement is just and reasonable in result and is in the public interest. Accordingly, we recommend for commission approval. That is the conclusion of my statement.
Mr. Martinez is available for cross-examination.
Thank you. Ms. Hogle, any questions? Ms. Schmidt?
No questions?
Mr. Dodge?
No questions.
Thank you. Anything further, Mr. Olson?
Nothing further at this time. Thank you.
Thank you. Mr. Dodge?
Thank you, Mr. Chairman. UAE would like to move the admission of UAE Exhibit 1, which is the direct testimony of Kevin Higgins in this matter. UAE Exhibit 2, which is the confidential testimony of Bradley G. Mullins. There's also a public version of that, of course, and the attached exhibits 2.1 to 2.5.
Okay, thank you. If there's any objection to that motion, please indicate to me. I'm not seeing any, so that will be admitted. Thank you.
Thank you. And as I indicated, although Mr. Higgins is in the room to answer questions, UAE supports the testimony but didn't intend to call anyone to testify to it this morning.
Okay, thank you.
Thank you.
Commissioner White, do you have any questions for any of the witnesses?
No, thank you, I don't.
Commissioner Clark?
I have a question or two just to clarify or confirm my understanding of a couple of entries on the exhibits to the stipulation. I'm looking at Table A, and Mr. Wilding, I think I'll address these to you, at least initially. So I'm in attachment A, page 1 of 10.
I'm going to have Ms. Stewart come up because she's the expert on
Sure.
attachment A and the rate spread.
Yeah, I think so, sure.
Why don't we
I'll
go ahead
direct
and-
my questions to you, and the chair's going to swear you, Ms. Stewart.
Ms. Stewart, do you swear to tell the truth?
Yes.
Thank you.
I doubt these questions are worth the commotion, but just to confirm, I'm looking at column 9 on page 1, which is the proposed EBA revenue, and the total under that column is 14.224 million. So you're with me there.
Yep.
And I just want to confirm my understanding of how that relates to the 15 million. And I think I see on the next page that there's a balance from the prior EBA period of 791,000, basically an overcollection that is taken into account in the EBA revenue for 2016 that we just talked about. Do I have that right?
You have that right.
Okay.
Right, and that was trued up through the end of August, I believe, and so it also includes 2 months forecast over collection.
Okay. Thank you very much. That concludes my questions.
Do you have anything else?
Nothing further.
Mr. Martinez, I just wanted to clarify your statement before that, the stipulation refers to additional technical workshops with respect to the energy imbalance market as necessary. So is it your statement that following the meeting that parties had last week, you believe that additional meetings should be warranted, and maybe when the commission issues an order on this stipulation, noticing up a technical conference is what you're recommending at this point?
Yes, sir. I think that it would be advantageous to parties that were not able to attend that and to the commission to be able to have these additional workshops as necessary to clarify the net benefit provided by the EIM within the EBA.
Okay, thank you.
Yeah.
And Mr. Thompson, I just had a brief question for you. In the EBA docket last year, there was quite a bit of testimony from the division regarding access to information, ability to audit. In your testimony on page 4, you indicate, I'll read your testimony. The division believes the company is maintaining its commitments made in the prior EBA dockets to improve the audit process. Do you have any interest in elaborating on that any further?
Which line item again?
On page 4, under paragraph 3, you state, the division believes the company is maintaining its commitments made in the prior EBA dockets to improve the audit process. And maybe your statement just stands for itself, but I just wanted to see if you had any interest in elaborating on that.
Well, we've been working since the beginning of the EBA pilot program to kind of flesh out how we can get our arms around the program, and over the years we've worked to try to get information, and we've in past dockets even had some settlement information about how we would work together to try to do that. And so it's been a history of just everybody trying to work together to try to get information, and sometimes there might have been a little bit of frustration on both parties' parts on how much information was coming forth and what was happening, and so we've had those types of things in prior stipulations of the EBA. But recently, it's my feeling that there's been, the company's put forth some really good efforts to try to help us get all the information we needed. And so we wanted to thank them publicly in the testimony and in my summary for their efforts to try to do that. And we've had numerous phone conferences. I've had conferences with Mr. Wilding about questions that I've had. So that's very helpful, and we'd like to encourage that and would like to give the company their kudos on that. So that's what I'm trying to elaborate, is it's kind of been a process. Maybe it was rocky in the beginning, but it's getting better and better. Hopefully that spirit of cooperation will continue.
Okay, thank you, Mr. Thompson. I appreciate that elaboration. Anything further from any party before we adjourn the hearing? Ms. Hogle?
Yes, given that there is a stipulated agreement upfront,
Okay. Anything further you'd like to say about that?
well, the company appreciates everybody's efforts. There has been no opposition to the stipulation, and any interest of any speedy process, if you will, the company permitted everybody's interest given the level of officials rate change that outcome from order today. The conditions.
Okay, thank you. I think it will probably be appropriate to take a brief recess to consider that motion, but before we do so, I'll go to the other parties and see if you have a position on the motion. Ms. Schmidt?
The division supports the company's motion.
Okay, thank you. Mr. Olson?
We have no objection to the motion.
Mr. Dodge?
Same.
Any questions from Commissioner White or Commissioner Clark before we adjourn?
None here.
Does anyone object to a brief recess without a time certain return that we'll just return as soon as we can? Is any objection to that? It shouldn't be too long. Okay, we're adjourned, or not adjourned, we're in recess, sorry. Considering the motion for a bench ruling, the commission finds that the stipulation submitted on September 28th in this docket is consistent with, well, the commission concludes that the stipulation is consistent with the relevant statutes and rules and orders, and we find that it's in the public interest, and we approve the settlement stipulation. And we will issue a written order subsequent to this hearing memorializing that bench ruling. I'll ask Ms. Hogle and Ms. Schmidt if you have thoughts on timeline for submitting the revised tariff sheets and getting a division review of those tariff sheets. Have we had any discussion over the timeline for that, or do we have an idea what we'd be looking at for that, Ms. Hogle?
We have not had a discussion, but if it pleases you, we can have a discussion right now, or we can do it after the completion.
It can happen after the hearing. I just was asking about that. Anything further before we adjourn? Okay, thank you. We're adjourned.